appeal party in the matter of Michael O'Hagan, FX Class Representative Limited, and Evans and others.
Yes.
My Lords, I was taking you through the judgment in the parts where the tribunal dealt with carriage, and I just got to paragraph 293, which is on page 395 of the judgment.
Yeah, I'm sorry, I was just puzzled by a bundle that's been put on our desk. Not mine.
Judgment, page 395.
What's this?
There might have been some insertion.
Okay.
There might have been some insertions.
Yeah.
Insertions over the night.
Right. Okay, well, if there are insertions,
Forgive me, my Lord.
right,
Sorry
okay.
that your table was cluttered.
Yes, Mr. Chairman.
On page 395, we see at paragraph 293 the conclusion, having taken certain extracts from the two parties' submissions. They say, we consider, at least given the points articulated by the applicants in this case, a relative evaluation of each approach will involve a consideration of the merits into which we cannot and should not be drawn. And we make 3 points about that. First, we fully agree that in determining carriage, the tribunal should not have sought to evaluate the merits of the two claims. That is a correct direction in our submission in law. But unfortunately, we also say the tribunal then later fails to follow its own direction because it expressly seeks to evaluate strength, relative strength. Now, the tribunal then turns in the next section of its judgment to funding. And as you'll see from the outset, the O'Higgins class representative objectively had a substantial advantage when it came to funding at the hearing. And you see you see that in paragraph 301. You see the funding of the O'Higgins PCR is little over 29 million. And initially, the funding obtained by the Evans PCR was little over 18.5 million, and it was increased, as you see, to 22.5. And you see the conclusion in paragraph 303. Now, the tribunal then identifies the various arrangements under which the lawyers were acting and the degree of ATE insurance obtained and the payments made to date. And the funds actually available are then summarised at page 402 of the judgment in the table that you see there.
Yeah.
And you see the O'Higgins application is ahead with 16.6 million against a little over 14 million, so a difference of approximately 2.5 million. And you see the conclusion that the O'Higgins PCR has more funds available than the Evans PCR by their reckoning. They say that, and they say, albeit the tribunal goes on to note that the Evans sums are stretched a little further by slightly more conditional fee agreements from counsel. So this appears to be possibly a point or half a point in favour of O'Higgins. Up to now, everything's been a square draw. The tribunal then turns to the budget plans for future spending, and you see at page 320, paragraph 325, which is on page 406. They say they say the consider of question of how the funding is going to be spent, we don't consider to represent much, if anything, by way of a relative difference between the two PCRs. We do consider it significant that both PCRs have, in our judgment, underestimated the difficulties of bringing this claim successfully to trial and beyond. We consider that both parties should have budgeted for a spend for the future of not less than 25 million, given their rate of expenditure to date. So So that is a point against both, effectively. The tribunal then turns to consider the legal teams and the experts retained. And at paragraph 329, we see, objectively viewed, there is no material difference between the applicants' teams. And the same is said of the advisory panels in paragraph 330. So a score draw on teams. Then at paragraph 33, it comes to costs recovery and ability of each PCR to pay the respondent's costs. And at paragraph 338, you see, which you see at page 411, it notes the significance of this factor. If I could read that to you, it says, it is thus clear that the collective action regime leaves a successful defendant significantly exposed when compared to an individual action. In an individual action where costs follow the event and the claimant loses, the claimant is exposed. It is for this reason that the tribunal rules list as a specific factor to be taken into account the PCR's ability to pay the defendant's costs, were the tribunal to make such an order. Equally clearly, it is for that reason both PCRs have taken out ATE insurance and incurred significant liabilities in doing so. So clearly it notes it is a significant factor. And then at paragraph 340, it notes two distinctions between the ATE insurance of the two PCRs. First, it notes that the O'Higgins PCR PCR's ATE insurance is marginally more robust than Evans. And then it says this under, you see at the foot of the page, 411, extent of insurance. Here there is a material difference between the extent of cover. The O'Higgins PCR's ATE insurance runs to 33.5 million, whereas that of the Evans PCR's ATE insurance has a limit of 23 million. This is a significant difference in amount, although we would note that if the collective action proceeded to trial, we consider that the respondent's costs would comfortably exceed even this higher amount. And then it goes on to explain why it reaches that view. So, so ATE is clearly a clear and significant factor in favour of O'Higgins. So at this stage, O'Higgins is one clear point, maybe 1.5 points up on costs. Then at paragraph 341, the tribunal considers various other matters, and it concludes they are immaterial. And then the tribunal then turns to the ability of the PCR to fairly and adequately represent the interests of the class members. You see that on page 412. And you see at paragraph 346, at the top of page 415, that includes that this is not a point of differentiation between the two applicants. And then it turns to a point on which we had much debate, which was the timing of the applications and the question of relative priority. Now, one might expect that the fact that the O'Higgins application was filed some 4.5 months before the Evans application to be a rather significant factor in its favour. But the tribunal concludes at paragraph 300.
Why?
Because they have taken the risk of going first, and the others are then able to effectively free ride in their wake. But
the person who rushes in gets ahead of, I mean, I can't think of many other sort of situations where the mere fact you're first.
Well, I don't think that I suggest
it gives you a greater merit.
Well, I don't. It's not a question of merits.
Well, merit as a representative. Not merits of the dispute.
No. Well, one does have to take into account in our submission the fact that the person that goes first, of course, articulates their case. They put it on the website. Others have a chance to look at how it's framed. The class is all defined there. And if you encourage a situation where others then belatedly come along and seek to improve on that, it's going to become a very difficult.
If the Evans case was simply a blueprint of your case, there might be some force in that point. But then the whole thrust of this argument is, and we spent 3.5 days arguing about it, that there's a difference between the two.
Well, there's not much.
I can't for the life of me see what the force of this point is.
Well,
anyway,
It's less than tortoises, isn't it? You've got a rather clever hare who looks
Yes.
at the internet and says, sorry, tortoise,
says, I'll learn from the hare. I mean, from the perspective of overall administration of justice, to have a bit of competitive bantering between two potential claimants improves the quality of the winner.
Well, I think
absolutely
if
understand
I
the
think
forensic point.
I think well, we actually disagree in the sense that when there is a question of a few weeks between, but when there are 4.5 months, and somebody has got through as past the CMC and beyond, and somebody comes along with another case which is very similar, with a very similar class and a very similar case theory, as the tribunal recognises, it should be a factor. But this is not where I am headed from, because I recognise this is not the point on which, the principal point at least, on which I'm appealing by any means. What the only point I wish to take out from this is the conclusion that that comes on paragraph 304. You see at the bottom of paragraph 348, it says, we do not consider timing to be a relevant factor in the present case. And at 349, it says, in the circumstances, we make no finding as to whether the O'Higgins application was unduly early or the Evans application unduly late. It seems to us that there are points to be made on both sides, and they effectively cancel each other out. Moreover, given that this is the first carriage dispute to reach a hearing in this jurisdiction, we, for these applications only, consider that relative timing is an immaterial matter. So it's absolutely clear what the tribunal's view is here. Timing is a score draw. That is what it says in paragraph 349.
So you don't in fact criticise them in the way that you lightly sort of trailed in your
My lord,
remarks.
that's correct. No, we don't. I mean, if it was reopened, we would like to re-argue it. But that's that. But we are content to rest on the fact that when you go through all of these objective factors, they are all expressly a score draw, absolutely clearly a score draw or immaterial, bar two, where O'Higgins is ahead. First of all, O'Higgins is up on funding to the tune of $2.5 million. Now they say, oh well, Evans has managed to stretch its funding a bit more. So you could say, okay, well that's half a point. Possibly, you might even say it's no point. It doesn't matter, because one point is absolutely clear, is that O'Higgins has got over £10 million more in ATE funding, which is clearly a significant amount, and particularly in circumstances where the tribunal anticipates a shortfall. And it is also a point that reflects a express provision in the rules about the suitability of a PCR, which is its ability to pay the costs of the defendants. So on the objective factors, O'Higgins is ahead at this point. And then we have the conclusions, if one can call them that, on the carriage dispute, which are at paragraph 389. Paragraph is page 440. And they say there, they make clear that their decision is hypothetical, but they say that they would be minded to grant carriage to Evans. And then they give, or they purport to give, reasons. Now the first subparagraph of the reasons, it just notes that both applications are very similar and the question is very marginal. So that is not a reason. The second is it notes that the first to file point is not a point in favour of Higgins, but again, as I've shown you, paragraph 349, they make no finding that that's a point in favour of Evans either. They say in terms it is an immaterial matter. So that isn't a reason either. Then the third subparagraph says it recognises that O'Higgins undoubtedly has the advantage in terms of the extent of its ATE insurance, which it notes is a material point. So yes, indeed, my analysis is correct. We are up a point. And it seeks then to somewhat downplay the extent of that material advantage on the slightly bizarre basis that neither PCR would be able to cover the respondent's ultimate tax costs, which you would think is actually a point the other way, because if you can't pay that, if the amount is going to exceed the ATE, then it's all the more important that you have such ATE that you do have. And then it does something very even slightly odder, which is it says if you divide the £10 million between the rival PCRs, it's less than 2 million a respondent, which does not, they say, amount to a particularly material difference. Well, with respect, one can all see that £2 million, even to a bank, is not insignificant. And then the fourth subparagraph is the only one that actually gives a positive reason why they have selected Evans over O'Higgins. And what it does is it asserts that they consider that the claims of the Evans PCR are said to be better thought through. And it then immediately caveats that by noting that it's drawing a distinction between two cases that have only just survived strikeout and that they have very serious concerns with the manner in which the claims put forward have been articulated. Now that caveat's rather important, as I'll come back to. Then they say, with that very substantial proviso, we have concluded, viewed side by side on a relative basis, the claims articulated by the Evans PCR have been, and it repeats, better thought through. And then it adds, and represents to our mind a marginally better attempt at capturing an elusive loss than that attempted by the O'Higgins PCR. Now, it then, in the fifth paragraph, asserts that we are in no sense seeking to apply any kind of merits test, but then it says, we are simply gauging the relative strength of the two claims in the sense described in paragraphs 98 to 118 above. Now that is a reference back, as I indicated yesterday, directly to the tribunal's discussion of the strength factor in the context of the assessment that is to be used in the context of the assessment of opt-in and opt-out under Rule 79.3. Now, it's very odd because earlier in the judgment, the tribunal at paragraph 286 seemed to recognize that relative strength couldn't be used in the context of carriage. But it then seems to change course when it comes to this paragraph on the basis that apparently strength is somehow, in this sense, is somehow different than an assessment of the merits.
I wonder if all agree. I mean, you can scratch one's head over this subparagraph. It may be that all they're saying is that one can't ignore the fact that they found that both are equally unmeritorious, and for that reason it's irrelevant as between the parties. So when they say merits are not relevant, they cross-refer back to 98 and 118. They're saying in the next couple of sentences, the real answer is neither. They're both equally unmeritorious, but therefore we're not in any sense applying a relative merits test as between Evans and O'Higgins. You're both damned with the same tarred brush.
Well, yes, and if that assessment is wrong, then this assessment must also fall.
Well,
That's one of my points, but I'll
this
come on
is
to
the sentence that I asked you about yesterday afternoon. Put the same point differently. We consider the essential question is to ask which applicant best serve the interests of the victims who comprise the classes for whom the PCRs wish to act.
Yes.
That is not an assessment of the strength of the merits. That's, as I read it, a repetition of the same point as they made at the end of subparagraph 4 about better capturing the elusive loss. Now, true it is not spelt out. That seems to be the thinking that they preferred in effect they preferred the Evans methodology to the Higgins methodology.
Well, if
So if it's not a merits assessment, then
well,
what is it?
yes, yeah, well, that's right. I mean, 2 points in that. I think one could.
Why, in other words, Mr. Chow, why would you say more than once
Yes.
that we are not assessing the merits if what they're then going to do is to assess the merits? I mean, it just seems completely, we're dealing with a very sophisticated and experienced tribunal and a very experienced High Court judge.
No, well,
unless he'd gone completely off-piste, it does seem very odd.
I think what this comes down to is this, that when you look at the discussion of the strength factor, they don't regard that also as an assessment of the merits. They say when we look at strength for the purposes of opt-in, opt-out, they also say that is not an assessment of the prospects of success, the assessment of the merits. So I think they use merits as a sort of perhaps a shorthand for a kind of final determination, a mini trial, if you like, something different from strength, which they regard as something akin to the kind of assessment that you make when you're looking at good arguable case, plus some indication of the probability of the evidence coming up. So if you like, I think what they're saying is strength is an attenuated form of looking, it's an attenuated form of looking at the merits. But although when they actually describe it, it seems to be, to me at least, to us at least, to look very much just like an assessment of the merits. And indeed,
they're just really reflecting where they got to, right or wrong. They got to the point that neither PCR had met a viability threshold at this stage, subject to amendment, etc. And you couldn't ignore that, but they're saying, you know, applying the test we set out in 98 to 118, you're all rubbish. But as between two rubbish PCRs, Evans has better articulated a theory of harm.
well,
To that extent, obviously merits a part of the...
That is an assessment of the merits, you see. I mean,
Right.
that just is. And they, I mean, there are 2 points I want to make on this actually before
Just
before I
relative
forget.
merits. I mean, there's a distinction between flat merits, you're both rubbish, or you're slightly more rubbish than you are. Relativity is what we're dealing with here.
Yes, it is, my lord. And I come back to that in just a moment. But before I forget, I do want to just pick up on one point that my lord, the Chancellor mentioned, which is that the sentence, the reformulation, to put the point differently, question, the essential question to ask is which applicant will better serve the interests of the victims that comprise the class. That is a paraphrase of the test that is used in the Canadian jurisprudence and that in relation to carriage. And it is, if you like, it's the ultimate test that one sees. And it's, one can, if one, where's the, one can see it in their judgment. They gave a judgment previously, the tribunal, on, in relation to when the carriage dispute should be heard. And in the course of that judgment, which I believe is in the, it's in key volume 3 at tab 54.
Sorry, tab.
It's a key volume 3 tab 54.
Yeah.
And in that case, they set out some of the Canadian jurisprudence that they were taken to on page 3249. And you see they cite the judgment of, in paragraph 40, they cite the judgment of in Wong and Marriott. And you'll see there in paragraph 23, that's quoted, the question before me is which action is most likely to advance the interests of the class members, provide fairness to the defendants, and provide access to justice, behavioural modification, and judicial economy. And that's the sort of touchstone, if you like, that the courts in Canada approach. But then they do so by looking at a whole series of factors. And you see them set out there. And you ask for some assistance on the sort of factors that should be taken into account in carriage disputes. But one thing is clear to come on to is that under the Canadian jurisprudence, you don't look at the merits unless there's an absolute and sort of egregious difference between the two, clear and egregious difference, not when the difference is terribly marginal. So that's
some of those factors
yes.
wouldn't, as such, necessarily fall under the heading of merits in the way we've just been discussing with my lords, but things like class composition and definition of class, the selection of defendants, correlation of plaintiffs and defendants and the like, class period. In other words, it's not so much the merits of proof of a case on behalf of the common claimants and common defendants.
Yes.
There is a difference that you alluded to at the end of yesterday between the class definition adopted by Evans and those by O'Higgins. Do you want
Yes.
to say anything more about that?
Yes, I do, in the sense that I accept that class definition in that sense is slightly different from, let me put it this way, class scope is different from the merits.
The scope of the class as
Yes,
defined.
and it was a point that we made in our favour below, and we said that when you look, for example, at the two classes side by side, our class, we didn't say it's better because it's wider, full stop, but we said it's better because it matches the infringement finding, because we have the additional two trades.
Evans said, actually, when you look at the type of infringements, some of them don't actually give rise to common issues, so not suitable for collective proceedings. I mean, do you maintain your criticism of, do you maintain your argument, and do you say
Yes.
that the CAT
Yes, well, this was
placed any weight on this?
well, this is what I come on to. Very important point. The basis on which they said that they didn't raise common issues, but the inclusion of benchmarks and resting orders, was they said there was what we call their winners and losers argument. They said, well, some people, maybe most people, will be on the wrong side of these, but some people on some occasions will have benefited from them. And our argument was, well, that doesn't matter, because what matters is net loss to the class. And if it's clear that everybody lost, even if on occasion they might have been on the right side of one of these transactions, then you're entitled to claim. And we had a debate that was almost identical to the debate that was had in the Gutman case in front of this court on the question of liability, whether you can have, whether, if you like, it's collective liability or individual liability. And I can give you the references where Ms. Wakefield and I, in fact, had that debate. You can see it in the Evans skeleton on carriage at paragraphs 31 to 36. That's supplemental 67 at 3780 to 377. Our reply to that, it's in the supplemental 62, tab 62, pages 3549 to 3550. And the transcript references are particularly important, where we expanded on these arguments. Day 4, in the supplemental volume, tab 70.E, 4618 through to 4620, and the response on day 5, supplemental 70.G, 480802 to 4804. So we had a long debate that almost mirrors the debate that was then subsequently had in Gutman. And I, in the best or perhaps worst traditions of the English bar, was on the opposite side of the side I was on in Gutman, where I was unsuccessful with Mr. Harris leading on the point. Now, now the tribunal makes no mention of that at all in its judgment. And this is, you see, this is part of the problem of trying to interpret.
It does mention the
it mentions
difference between you.
No, it does, but it makes no.
So that is-
Yes, but it makes no finding on the point of law that was argued. So, because it was principally argued against us on the basis of a point of law, that you couldn't, in collective proceedings, bring those types of claims, and that point of law has subsequently been decided in our favour in Gutman. But and this is the problem, you see, with interpolating into these incredibly brief reasons, if they can be called reasons. They're not reasons in our submission. It's just an expression of preference. Why they came to the reason they did, because it may be that it's because they preferred the causal theory that they advanced or articulated, or it may be because they didn't like our broader class, or it may be that they made a mistake. I think I'll come on to the most likely reason. They certainly made a misapprehension as to the nature of our theory of causation, but we don't know.
What are you suggesting that we do? That we send it back to them and tell them to do the job properly?
Well, what I suggest is that you can see from the judgment that on all the objective factors which they evaluate and go through, O'Higgins, they are all either neutral or O'Higgins is ahead on one of them, on ATE.
Well, that's what you submit.
They then say, well, there's no doubt about that. They then say,
Well, you say that.
no, well, there's no doubt
It's
about
true
what
that
their
the
findings
tribunal
are.
don't deal with this point that my lord has put to you, but we might take the view that, in fact, the Evans class was better thought through because of this very point, because the other two categories identified by the Commission don't actually, for whatever reason, don't actually give rise
My
to
lord,
significant loss.
you
or
would
whatever.
have jurisdiction to do that, but I would respectfully submit that you haven't had the submissions, and we haven't had the time, and we don't have the time adequately for you to resolve that
point yesterday.
Forgive me?
You trailed the point
I
yesterday.
trailed the point.
so
Yes,
it's
I
difficult
did,
to
but
say we shouldn't deal with it.
I respectfully submit that it's not possible on the basis of the material that you've had to date to resolve this point fairly.
Well, in that case, we'd
One
have
would
to
have
send,
to. You haven't
we'd
heard
have
the
to send
evidence.
it back to
Uh,
either
it-
this cat or another cat.
That may be, or alternatively, as I said, if you're with me on the strength of it, which I'd like to just elaborate on a little, then we say you should just resolve this in favour of O'Higgins, because they have made assessments of all the objective factors. They come out with one factor ahead for O'Higgins, and then they take into account strength. And this is our first ground of appeal, is one cannot, in my respect, but one can interpolate perhaps to some degree into a judgment. One cannot simply delete a sentence. And they say in terms, in that subparagraph 5, we are simply gauging the relative, quote, strength of the two claims in the sense described in paragraphs 98 to 118 above.
It gets more complex, doesn't it? Because, I mean, you say, I mean, just looking at paragraph 389, sub 4 and sub 5, I mean, you say O'Higgins is ahead on ATE,
Yes.
broadly speaking.
Yes.
Evans would say, actually, they marginally thought through their case better, whatever that means. I'm just reading the
Yes,
text.
yes.
Whatever it means, you say, I can't tell,
Yes,
understand.
yes.
If it goes back for an evaluation, then we're going to get into the fact that Evans have now upped their game in relation to ATE, aren't we?
Well, there are two answers to that, if I may, on ATE. The one is that they shouldn't have taken into account the ATE, their up to game on ATE, because this was late evidence.
Well, they plainly didn't, in fact. They
No,
said
well,
that they said,
Yes,
I mean, the tribunal says irrespective of
yes,
the new evidence, which they
Yes.
were pretty unhappy about
Yes.
being given.
that's right.
They
And
say they would have preferred Evans, but if it's
Well,
done again now, it's not late evidence, is it?
My lord, well, one would have to, if it is redone, as they say, if it is redone now, yes, but it would have to be, one would have to go back to the cat and see, but
But your big point.
but my big point is
your big point would evaporate on.
no,
being redone, wouldn't
well,
it?
it wouldn't, because I'm inviting you now to say, well, but there are two important points. First of all, I'm inviting you now to say, on the basis of the evidence that was before the CAT at trial and at the hearing, forgive me, and on the basis of their evaluation of those factors that it was lawful to take into account, we were ahead. Point one. Point two, yes, they sought to neutralise that factor, but they did so with late evidence. And and I will say to you that the CAT was wrong to even allow that late evidence. It seeks to recharacterise it as late material. It is not. It is late evidence.
Right, if it's late evidence, but ...
Well, no, but there's late evidence, and then there's evidence that is served after 2 months after the trial, just before
are you
judgment.
saying that so far as this court is concerned,
Yes,
if you're inviting us to make the evaluation ourselves, which you've just done, should we just ignore the fact that they've, as my lord puts it, up their game on ATE? That
Yes,
seems to me
yes,
to be
because
very extreme.
well, my lord, we do make that submission.
Material
But I
is
have an
before the
alternative.
court.
I have an alternative submission, which is that on the basis, the way that the tribunal approached it, and this is the alternative, is to say, and this is, if you look at paragraph, page 445, paragraph 406, it doesn't just allow the late ATE insurance. And if you read paragraph 406, what it says is, if we had been with O'Higgins, we would have allowed it to match the ATE of Evans. And if they had matched it or beaten it, then O'Higgins would have gone forward. So if you're not with me on excluding it as late evidence, then the CAT's own approach is to give us the opportunity to match. And so that would be that's my alternative submission, that you should follow what this is obiter upon obiter, but it is a decision. So that is the proper approach in my view.
It's a beauty parade whereby they're constant. I mean, it's almost the nature of the beast. People are allowed to put more and more makeup on, aren't they?
Well, in my respectful submission, it is really important to try to bring these into some kind of order, and that's why I do say
it's not great for any.
I do say that it was extremely difficult having to deal with the incremental admission, sort of improvements to the funding position of both parties in the run-up to the hearing. There were clear procedural directions, and we all then proceeded and had a whole hearing, including cost counsel, on the basis of certain costs and ATE provisions. For one side to be allowed then to come along months afterwards, weeks afterwards, and say, oh, and I've got something that's better now. Then the whole process becomes a complete becomes procedural anarchy. That's why I do say this was late evidence, and they seek to recharacterize it as late material. It wasn't. It's just late evidence, and they say if it was evidence properly so called, they wouldn't have let it in. So I do say the CAT was wrong on that. But alternatively, I say, well, then follow their matching proposal, which is what they say they would have done.
What should they do in principle? I mean, it's a very odd situation. You've got this sort of competitive tendering process whereby, almost by the nature of the beast, each PCR applicant improves their offer as the proceedings go on, as they're matching whatever happens on the other side. Some stage, the CAT has to simply draw a line and say, you know, for good or for ill, you're both going to be able to do the job properly. We've got to decide. We can't allow you to both expend more and more money when one of you is going to be a loser.
Yes, no, yes.
There needs to be some sort of procedural mechanism to draw a line, to enable them to take a decision. It's bound to be imperfect because you're dealing with two very experienced, very well-funded organisations, both of whom would be able to do the job. It's a way of just finding a sensible way to make a choice.
My lord, I don't
Is it
dissent
like
from...
best and final offers?
Yes,
when you're
my
bidding
lord,
to
yes.
buy a house,
But the best and final offers must come in before the hearing. You can't allow, under the rubric of recharacterising...
Well, actually, isn't the point that to take my lord's point, that one suggestion would be that, you know, either the rules or by direction, the CAT says best and final offers by a certain date.
Well, in effect, we say that was implicit in the directions that it gave in the run-up to the hearing. It said you will put in your evidence on this date, you will reply on this date, you will put in your evidence on this date, and they've just allowed.
No, this is much more. This is a more specific.
More specific. Well, one could say that would be sensible.
Like,
but this,
like
I
a less
would,
order, effectively.
Yes.
That
Yes.
you put in your material by X
Yes.
date, and we won't look at anything else that's put in after that date. Full stop.
quite agree. But in the absence of that, it was just taken as read, at least on our side, that at least you couldn't put in something post-hearing, and then to our astonishment, suddenly, weeks after the hearing, and that is a recipe for procedural anarchy. Our submission. Now, so if I may, because I want to leave my learned friend, trying to leave him as much time, can I try to rattle through then my grounds of appeal on this, which I think we've already got a good flavour of. The first one is we say it does say in terms, in subparagraph 5, that they are gauging the relative strength of the two claims.
Just before we go any further,
Yes.
Mr. John, I'm sorry to
Yes.
interrupt you. I mean, I should have said something
Yes.
there. I noticed Mr. Williams in court, but
Yes.
we're not going to get to costs today by any stretch of any means.
No, I think Mr. Williams may be here to deal with my submissions on costs of costs that I may not arise. There we are. Yes.
Yeah, I just didn't want Mr. Williams to be sitting in court. He
No,
may
no, no.
be so fascinated by the case that he wants to be here.
No.
Well, my lord, I am hoping for further revelations along the lines of the lizard, but but absolutely, there's no. I think I may be here to deal with some of the issues on after the event insurance and such like. Which have been touched
that's fine.
on.
I just didn't want
So
you to be here.
I'm not a mere spectator.
I didn't want you to be here under false pretenses.
I'm sorry to say. Well, I'm always under false pretenses, but not for the specific reason your lordships identify.
Right. Yes, Mr. Jones.
My lord, so rattling through the points on appeal. First of all, we say that to gauge the relative strengths of the two claims, in the sense that they describe in their earlier paragraphs in relation to strength on carriage, was an error of law, because under the statute, we see that the decision between two rival applications, the carriage dispute, is dealt with under section 78(2)(c) of the rules, and it talks about which is more suitable. And that brings in the criteria of suitability under section 79(2). Suitability does not include the strength factor, which is introduced in relation to opt-in, opt-out only in 79(3). And as Lord,
if you called it case theory, would that solve the problem?
it depends what you mean by case theory.
Well, I mean
Because-
what
yes.
Mr. Justice MacDonald meant in Wong and Marriott International, who you took us to.
Well, you see in the Canadian cases that they are very, even in relation to things which are touch on the merits, like case theory, they are very reticent to get involved unless there are very clear differences. And the tribunal says in terms that these are very, very marginal difference between these two. And to suggest that, we can delve in more detail, if you like, into the nature of the differences, but they are not, I mean, of course one can say they divide their class into class A and class B, but that is, with my respectful submission, a distinction of galactic over, simplicity.
But it's
Because
not, but
that can't be it. It must be that in some way they have articulated, their experts in some way have articulated a causal theory that they prefer. And that is not something that that the tribunal can sensibly judge. Certainly not a small difference at this stage of the proceedings. It's just
They've got to. I mean, the real problem with CAT has, they've got to make a choice. You
Yes.
can't allow, the same class to be carried by two people.
I accept that.
In
But
Libya,
then,
they describe it. It's marginal. You are choosing between two excellent teams, if you like. And how on earth do you do it when they're pretty much
you
after
choose,
extra time, 6 penalties each? It's still.
You do it on the basis of the objective factors, and on the basis of the objective factors, the O'Higgins team is ahead. You do not seek to assess the relative strength. Lord Briggs says in Merrick's, he says at paragraph 60 that the suitability criteria don't include a review of strength, and yet here
Relative strength. I mean,
well,
we've got to be careful how we've got to interpret paragraphs 4 and 5 of 389 as to whether they are looking at relativity or just simply saying baseline is we think both cases are very weak, which we can't ignore.
yes.
But we're choosing between two very weak cases.
My lord, well, we say that seeking to distinguish between two claims on the basis of their strength, which is what in terms, I'm sorry, but it is in terms what they say they are doing, is not permissible in law.
Okay, I mean, I'll have one last go at my point. I mean,
Yes.
I understand that sort of under case theory, you might suggest, and again, I'm just looking at what Mr. Justice MacDonald said, that by way of an example, you should only consider case theory as a relative criterion if there are conspicuous or egregious problems or readily
Yes.
apparent advantages and disadvantages, which
Yes.
may be a more nuanced way of putting the point.
Yes, I accept that. I accept that. My lord, I absolutely accept.
There's a slightly different point
Yes.
on merits, which is actually fit, if you like. It's
Yes.
scope of class, it's fit.
Yes.
These are collective proceedings, which is
Yeah.
why I was interested in the way you led off yesterday on
Yes.
this question of,
Of the two extra classes, but
well,
Yes.
there are two aspects.
so
of
the
it.
two.
One is,
yes, the two.
why have certain types of transactions been dropped from the class? As
Yes.
you put it, why have Evans done that?
Yes.
Because on the one hand, you say,
Yes.
as I think you trailed yesterday,
Yes.
people who have suffered from collusive activity are going to go without a remedy.
Yes.
On the other hand, the argument is, yes, but their loss may not be suitable to be determined in collective proceedings because it's just not common.
Yes.
The other thing is, as a case management issue, and by case management I mean focusing everybody's minds on the issues that have to be decided,
Yes.
is it better to focus attention by defining two separate classes, Class A and Class B, rather than not at all? I mean, that's not a merits point as such. It's a, you know, what does this vehicle look like? How does it fit in analytical terms the issues that the court ultimately is going to have to decide?
Well, I think
So that there's a slightly more nuanced way of looking at things. I'm trying to give some meaning to what the CAT said when they talked about our claims articulated have been better thought through.
Yes.
And part of that may be, you know, case theory, economic case theory, and the like. But part of it may be something else.
It may be, and in a sense, one is speculating, but I would suggest that the simple fact of division into two classes, which aren't really separate classes because they're subclasses in a notional way.
Well, the subclasses from your perspective, and they are two separate classes from theirs.
Well, because normally one will get into this, but the purpose of having separate classes is in some way to say if you actually have separate classes, you have separate PCRs and separate funding and so on. They have the same PCR, the same funding arrangement. It's just a notional breakdown. So and of course, and the question is, of course, they seek to say, well, there's this very clear distinction between trades with the cartelist dealers and trades with other dealers. But that's an empirical question because it may be that the real distinction, as I said, is between some other distinctions, such as, for example, between voice trades, which are the subject of the infringement, and e-trades, and you could equally break down the classes like that. And Higgins has always said in its case that it will consider subclasses if necessary in due course. But it cannot be a basis of distinction, a reasonable basis of distinction, just to say someone has broken down between two classes. There must be more to it than that. And the minute that you get into the more to it, you get into things like, well, their causal theory of two primary causes is better than our, or different from our theory of a principal cause with a contributory factor. That's straight deep into the merits, which is just not possible to assess sensibly on a very marginal basis at this stage. But if I can, because I
Move on. Sorry.
Can I run through them?
Give me the answer. I mean,
I hope
I will look at it
yes.
on the transcript.
Yes.
And I've listened to it.
We need to move on because we need to give
Yes, of course, yes, exactly. So the second reason why we say that the tribunal's reasoning can't stand is the one that's alluded to by my Lord Justice Green. And that this is all premised upon the assessment of the absolute strengths of the parties' cases. And they say this in terms. They say that, as my Lord Justice Green said, they effectively say, we don't believe in either of your case theories effectively, and they're both strikeable, but in some way, one is somehow less strikeable than the other. And it doesn't really, in our submission, make much sense to say that of two cases that you've said are apt for strikeout, that one has got a stronger relative strength than the other. But even if it makes sense, if they are wrong, as we both say, on their assessment of strength, if the tribunal has erred both in its approach to the pleading of these claims and has approached it on an unfair basis by not giving us notice of its complaints and in the nature of its objections to our pleading of these claims, and if the tribunal has also made a litany of errors on the face of the evidence as to what was said and what was not said, as we've both maintained and maintain, then it cannot be that a relative assessment of the strength can still be upheld. And this is really the short point here, because if I can just use a crude analogy.
I understand that, but if you're right, you quash and send back.
Yes. I mean, if a person has misweighed two suitcases, and because they say they've used the wrong scale and they've put them on correctly, and then they say,
it taints the entire analysis.
yes, of
from
course,
top to
you
bottom.
can't then
That's your
say,
point.
yes, particularly when you say that the difference in weight is very marginal. You can't then say that's a.
If this is a judicial review question,
Yes,
you would quash and send back. You wouldn't make the decision yourself, would you?
that's right. On that basis, and if you're with me on that basis, and that's really the short answer to this point, is that if we are right on the assessment, and what's interesting is that the tribunal actually agrees. The tribunal agrees with that because they say they agree with it in the judgment, but de facto, because they talk about with that very substantial proviso that we are talking about a distinction between two cases that have only just survived strikeout, and they actually expressly agree with that really in the reasons, the limited reasons they gave that I took you to at the outset. At the back of tab 16, if I could just remind you of that, because it's 496.
Yeah.
Where you see they say they have given permission on the carriage, and you see the last sentence. They say, in such a case, given the interconnectedness of the discretionary elements in the decision under appeal, the tribunal's contingent decision on carriage would doubtless be reconsidered by the Court of Appeal. So they are themselves recognising that it's all inherently interconnected. So that is our second ground of appeal. Third is we do say that this does breach the common law duty to give reasons. We are entitled to understand why the particular dispute has been resolved in the way it has. And even when you look at these incredibly elliptical, opaque comments in light of the evidence and what was submitted, one just doesn't know whether it's one particular aspect that it may be that it's all based on their misconception, for example, that we had never relied on collusion on spreads. You've seen from the aid memoir table that I carried out. The first item gives you the references to where Professor Breeden did rely on collusion on spreads. It may be that we just don't know.
I mean, hang on. They did give reasons. You've just taken us through some length.
Well,
they weighed a whole load of factors and said most of them are neutral.
Oh yes.
I think in reality you're criticising the reasons,
The
not
reasons.
the absence of reasons. You just don't like the specificity and the result. But to say that they haven't actually given reasons at all.
Well, they haven't allowed. No. Well, I think it is right to say they haven't given reasons because reasons must allow
Really,
you.
there was some Sunday evening drafting going on.
Reasons must allow you to understand. And reasons must allow you to understand why the case has been decided the way it has. And when you have expert evidence and you're making a decision on relative strength, that means going into some degree of specificity. And there's no degree of specificity, and we are all left guessing what it is that just for your note, we did bring this in our ground of appeal, absolutely clearly on the face of it. It's volume 1, tab 6, paragraph page 84, where you see paragraph 5, sub 6, and these grounds of appeal are identical to the ones that went to the CAT. They granted permission, and you've seen what they said in their tab 16, and that's the only supplement. And the case law it does not suggest that we have to ask them for reasons. The appeal does that effectively. And so for all those reasons, we say that this matter should have, first of all, we effectively put our case in the following way. We say, first of all, if you take away the strength factor, then the only remaining reasons show that this goes to Higgins. The only provider that's subject to is the point about the later evidence. We say that the tribunal should have ignored that later evidence. It was evidence, it was not, as they call it, at paragraph 401, material, quotes. It was evidence, and they accept in 398 to 400 that it was a deliberate exercise by appellants belatedly to improve their offering. Or alternatively, we say that the court should adopt the solution of allowing us to match, which is the tribunal's own solution that I've shown you. And in the further alternative, we say that this court should remit. With respect, we don't think that in the context of today's hearing, at least, that it is possible for the court to sensibly reevaluate these matters like case theory and so on. I'm perfectly content if the court wishes to schedule a further hearing to reevaluate those matters for itself. It would be entirely within its jurisdiction to do so, of course, and we would be content to argue it. But then it should be argued on a proper basis with full argument, so that we can both put our cases on our relative case theories and so on. And in truth, we have to concede that, given the absence of live experts, it's perhaps not the ideal forum for that dispute. And you have my submission that in light of the adverse comments of the CAT, we say that this should go back to a differently constituted panel of the CAT.
Okay. Thank you, Mr. Yes, Mr.
Lords, I'm going to tackle three main topics. Firstly, jurisdiction. Secondly, reasons. And then thirdly, look at the judgment and identify what we say are the key points of distinction that led the tribunal to its unanimous conclusion that Mr. Evans's application was better thought through and therefore more suitable for the carriage of these claims. Dealing first with jurisdiction, in summary, we submit this is not an appealable decision. Carriage, as distinct from certification, is only potentially challengeable by way of judicial review. And I appreciate this is a point not just for this case, but of wider significance for the court. The relevant test for the purpose of deciding whether a decision of the CAT is appealable is it one as to the award of damages within the meaning of section 49(1)(a) of the 1990 Act. It was considered by the Court of Appeal in the context of this regime in the Merrick's jurisdiction case. I'm not going to ask you to turn this up, but it's Authorities, Volume 2, tab 29, relevant passage, paragraphs 23 to 27, which are pages 640 to 641 of that bundle. And it was also considered in PACAR, Authorities, Volume 3, tab 35, paragraph 58, which is at page 881. The test in the context of the collective actions regime is whether decision in practice is the end of the road for a class action of this kind. The concern is that a decision of the CAT which has the practical effect of preventing a class action from proceeding at all, and thereby preventing a class from receiving an award of aggregate damages, should be treated in the same way as a decision which in practice prevents an individual from obtaining damages. So an interlocutory decision that's determinative as to whether a class will obtain damages falls within the appeal right. Now, before we say why this carriage determination and carriage determinations normally are not such a decision, we need to address what the CAT has recently said about this test, because there's a danger here that we submit that the CAT is going wrong on this. The CAT granted the O'Higgins PCR's application for permission to appeal by way of an order on the 4th of October 2022, You don't need to turn it up, but it's in the core bundle, volume 2, at tab 15. We then wrote to the CAT on the 10th of October 2022, asking for confirmation that permission to appeal for O'Higgins included permission to appeal on carriage, given that we had made a submission to the CAT that there was no jurisdiction to appeal carriage. The CAT wrote to Mr. Evans on the 14th of November, and that is at core volume 2, tab 16, confirming that permission had been granted in respect of carriage, cross-referring to the CAT's decision in the merchant interchange fee umbrella proceedings on permission to appeal. That mouthful abbreviates to the MIF PTA ruling, which is 2022 CAT 50, and that authority which we should turn up is in authorities.
Paragraph 18 of that.
So
Yes.
authorities bundle.
55, tab 49.
Yeah.
At page 1505, you see there, paragraph 14, the test is one where the question is essentially whether the decision affects the amount of damages to be awarded in some causal way. And then over the page on 1506, as my Lord Justice Green has pointed out, paragraph 18, it then essentially says that trying to figure out which interlocutory decisions may prevent an award of damages is all too difficult. It establishes a presumption at 18 that any contested interlocutory decisions, even those of a case management nature, are for the purposes of permission to appeal applications to be assumed to meet the requirements in section 49 that they affect the final substantive outcome in terms of the level of damages awarded. It then says that when it rules on a PTA application, the CAT will state if it has reached the conclusion that the presumption does not in fact apply. So, first point, it's unclear what that presumption is doing, but in any event, we say the CAT's wrong to, in law, to establish such a presumption. The CAT's concern appears to be that the scope of section 49 is currently unclear, and that has generated protective judicial review applications, as took place indeed in that case, refers to that at paragraph 9, and that in light of what it says is a problem with protective JR applications, it's appropriate to construe section 49 widely rather than narrowly in permitting appeals. But in our submission, the meaning of section 49, whether it causes rise to difficulty or not, that can't drive the proper interpretation of the section. It's just got to be properly interpreted.
Well, it runs the risk,
applies.
doesn't it, that every case management decision the CAT makes
Yes.
can be, as it were, shoehorned into section 49 via this presumption.
Yes.
Because in one sense, they can all be said to affect the ultimate outcome.
Yes.
So if the CAT makes an unless order, unless you produce an expert report by next Wednesday, you can't call any expert evidence, then which is a case management decision par excellence, not to be interfered with on appeal. There's no error of law, but on this hypothesis, they could give permission to appeal.
Yes.
It's quite complicated. But there's no gap in justice. It's either JR or it's an appeal. If it's JR, you end up with a JR from a specialist CAT presided over by a High Court judge to a non-specialist High Court who doesn't have a specialist High Court judge presiding necessarily, and then you go to the Court of Appeal on a point of law. And so, I mean, a number of the cases have said actually, given that it's universally applied across the board, there's going to be some remedy somewhere, and actually the difference between a point of law appeal and a JR isn't very different. There's some suggestions in the case law that Enron and others, you ought to give a fairly broad application of 49A And the case law has held that if you bring it to an end, I mean, if you look at Merrick's, what they treated as a point of law there was very broad, including, for example, whether there should be a trial within a trial at the first stage of certification. That was an admissible point of law. The Court of Appeal disagreed with the Supreme Court. I mean, it may not matter at the end of the day. From the point of view of procedural economy, making sure that you don't have to go round the houses, isn't it better to have a broad appeal right as opposed to JR? Everything goes into JR, then it comes to us anyway. It may not matter at the end of the day, just what's the best procedural route?
Well, at the end of the day, the primary legislation draws a distinction.
It depends on those words, as to damage. I see your point about presumption in paragraph 18. I wondered if there was some attractiveness in the other language. Does it affect the final outcome in terms of level of damages awarded? And the case law suggests that if it's a strikeout for whatever reason, then it affects it because there's zero. If it knocks out half of the claim, it affects it, the level of damages, because some of the claim has gone. The Supreme Court in Merrick suggests that any sort of a decision about certification, if it leads to no certification, would be as to damages, because they dealt with a whole series of points as appeal points there. We know that, we just look back and see what they did. I mean, it's not easy, but we've got to work out a way of ensuring that people don't just dissipate into the High Court and the Court of Appeal as they have to here, multiplying costs. You know, we're sitting as a Div Court and a Court of Appeal to try and overcome the sort of procedural wrigglings that are going on at the moment. We need to find a way through this, just for everybody's benefit, to avoid costs being wasted.
Well, that's the wider public interest about this issue that I mentioned at the outset. And I'm not, with the Lordship's permission, I'm not going to spend time debating that.
It's more our problem than yours.
It's a problem in this case because you've got a carriage dispute where you've got two PCRs seeking to represent effectively the same range of victims of anti-competitive behaviour. So only one can go ahead, the other can't, but that doesn't mean the victims don't get representation, don't get the ability to pursue their claims for damages.
In a sense, I'm picking up my Lord's point as to why it may not matter at the end of the day whether it's an appeal or a JR, in this sense that it's a quintessential case management decision by a specialist tribunal, which involves a multifactorial assessment. And unless the tribunal has got, in appeal terms, unless the tribunal is clearly wrong, then this court doesn't touch it. Likewise, if it's JR, unless it is irrational or meant to be unreasonable, this court doesn't touch it either. So at the end of the day, as my Lord has said more than once, I think that how we approach the issue may not actually matter. But the point is a perfectly valid point. We've got several of these cases, as you know, where we're having to constitute ourselves as divisional courts in order to get over a procedural issue. It might be saying, well, isn't it better just to allow it to come to the Court of Appeal on appeal?
Well, in relation to...
I'm saying often enough, these are case management decisions which shouldn't come to this court. It may be that eventually somebody will listen to us. Maybe not, who knows?
But having said that, I mean, when you read out the appeal procedure, I mean the section 49A, I mean it's actually needs to be looked at quite carefully. The actual language is a point of law arising from a decision of the tribunal as to the award of damages or other sum. So damages, other sum, what is that? Is that distribution? But then brackets, other than a decision on costs or expenses. Now, is the claim that you, or the dispute you have, ultimately to be brought under the heading costs? Because we're really talking about who brings the case with a view to making a proper return on the funding investment, which will be wrapped up in costs at the end of the day. Does that mean it's costs and therefore judicial review? And if it's not, is it so remote, even on the MIF case, paragraph 18, it's not as to damages, because the damages case vests in the member, and we're only deciding who carries that member's case, and it goes on either way. might suggest it's JR, but as my lord says, it may not matter two hoots. But from our perspective, we're going to have to grapple with this and try and provide some guidance so that we avoid the situation of the proliferation of costs of expense satellite litigation.
And I think, given the context we're in, which is a carriage dispute, I mean, we've urged upon the tribunal in this case, both myself and Mr. John, with conspicuous lack of success, that a carriage dispute should be heard right at the outset. And it shouldn't wait for certification. That's what we originally argued. And indeed, half of the respondents agreed with us. The other half didn't take any position on that. And despite that, the count decided that, well, this is the first time we've got carriage, plus it's pre-merits in the Supreme Court. We think that's too early. But for the future, one would hope the carriage disputes, well, one might expect it's an issue for the first CMC as to whether carriage disputes are resolved right at the outset on a review of the rival applications for a CPO, and without the plethora of subsequent submissions that's accompanied this case. So it should be a sort of a quick look assessment. Now for that, you're in classic expert determination territory. And that really should only be judicial review.
And then prevent the problem that Mr. Jowell identified, that you keep on getting a retaliation in later and later and later, then having to have another opportunity to respond. I mean, that doesn't seem to be conducive to justice. It just proliferates costs. And when it comes down to, you get two very, very high quality organisations, it's an impossible choice. You've got to choose one. Someone's going to be a loser, someone's going to be a winner. In the overall, these things may work themselves out in the marketplace as people, they have to decide whether it's worth. If someone's in and they know they're a decent organisation, do you fight them, do you contest? It may be that quick and dirty is better.
And that's the list of factors you get in one in Canada, because in Canada, and it's not unique amongst the common law jurisdictions, and I appreciate, particularly with my Canadian citizenship hat on, that Canada isn't one single jurisdiction, it's a series of provincial jurisdictions, that they have settled upon, you deal carriage right at the outset because the dangers of just driving up costs. And so you do that, to use your words, quick and dirty assessment. Similar approaches have been taken in Australia and New Zealand. But
this court could say that for the future, it seems to us that carriage disputes should be dealt with at the outset.
Yes.
Well, ultimately, although it's a matter for the cat, but it seems to us that they should be dealt with at the outset. I mean, this is an absolutely classic example of why they shouldn't be dealt with in the way in which they were. I mean, no disrespect to any of you, but the amount of money that will have been wasted by this issue, it's just mind-boggling.
yes, it is a deterrent of funders as well.
May I just say that we respectfully concur with everything on
I know,
this
I
point,
find.
and we
Anyway,
both
This is weighing up the noddings. And
No, it's all nothing.
yes.
I think we better have a break.
For eyes.
5 minutes.
I'm very happy for this.
Well, I think I should, because ultimately it's quite important in this case. So you take away the stuff you're speaking on and you're left leaving it with 8 even though they don't actually find it. So I think I need to.
I think if you have them on here, you leave them where
fairly early on.
they're speaking, they tend
Okay.
to get lost, so Jem will just hold on to.
Just,
Sorry, they're here.
just,
Oh, fab, great,
Great.
great.
So I'm going to do standard.
Forever amazing.
I'm going to do reasons as terms of the judgment. Can I get the funding issue out?
Okay, that's fine. And how long do you need so I can sort of cut my cloth? I mean, I can cut my cloth down, quite short, but I think I do.
You take as long as you think you need.
Yeah. Obviously not like an hour.
Yeah,
No.
I've got about another 45 minutes to deal with stuff, and what are we going to do?
Yeah. And he's got to have a short reply. So
Yeah.
so between us we've got an hour really, So I ought to try to keep it to 15 minutes, basically.
It's 10.
Yeah, I've been my best. I mean, yeah, I mean, I may just, I'll do my absolute best.
It's-
And also, they may hurry me along. I don't
Yeah.
know. I suspect I won't get asked questions in the same way.
Yeah, but it, I mean, it does help that, you know, they've been through the reasoning.
Yeah.
They see the point of distinction.
Yeah.
So, you know, there.
Yeah.
And I think, I mean, it's so presentationally odd to have said nothing about funding in this goes to
Without quite saying that. I mean, it's almost as if he's, yeah.
And it's good moments. It can be quite difficult to nail down. It's like as Bill McLaren would
Like a
say,
lizard.
he's not a lizard.
No,
As Bill McLaren once famously described a scum half for an agency, like a baggy upper board where a baggy is a sort of fish.
Oh, yeah, okay, and I know what a bird is, obviously.
Yes.
I mean, he did seem to segue from, you should just award us carriage to, yeah, of course I should do this.
Well, I'm admitting he's lost the influence.
Yes.
Well, you know, it's not lost in permanency, but at the moment he's lost.
And the rest of it's a different
I think we'll be going on.
But probably with a direction for a date.
Before lunch, it's gonna finish.
Even though, of course, on our it just that doesn't matter because depending on the contrary, it's disruptive because it encourages people to buy funding, buy carriage in a way that just leads to uneconomic expenditure.
You need more and more undistributed damages and so forth.
Yeah.
Great stuff, right. So next one.
Yeah, exactly.
It is, isn't it?
Yeah.
But even if you just stand up and say, yeah.
That's the reason why that'll be their first date moment. So like, oh, all the other jurisdictions, 6 weeks. So I would
Score eyes.
Lords. So I've dealt with the issue of appeal as against review. As to the standard of review, whether it is appeal or is review, this court has jurisdiction to interfere where there's error of law, and the standard of review on that is effectively the same. I can't see a cigarette paper between the two. As to what is an appealable error of law, That was addressed in the Pateral, paragraphs 55 to 57, and I don't think I need to take this court to those paragraphs. Judgment over facts can only amount to an error of law where the decision is outside the generous bounds of that which the decision maker, here the cat, could properly and reasonably make. And the example that's given there is getting a decimal point wrong, manifest error. But that's exceptional. In our submission, the O'Higgins PCR's criticisms of the carriage decisions are simply not errors of law in relation to which this court can interfere. The tribunal didn't take the wrong high-level approach in our submission, which was to ask which applicant would best represent the interests of the proposed class members. This is just an attempt to have a second bite of the cherry in front of this court. I should take the second of my topics is to deal with the reasoning in the judgment. Because my learned friend criticises the reasons and says that falls below common law standards. If I can hand up judgment in Harris and CED-MR Purfleet, which addresses the topic of sufficiency of reasons. I'd suggest that when we finish looking at this, that your lordships place this at the end of volume 6 of the authorities bundle.
Yep.
The relevant paragraphs, and I should say I drew this attention to Mr. John's, this judgment to Mr. John's attention first thing this morning. The point of principle that we rely upon this is at paragraph 21, where English and Emery-Reinbold is cited, and then Lady Justice Smith says, paragraph 21, it's always desirable that judgment should be comprehensible for the first-time reader. This judgment was not. However, that's not the test of the adequacy of the judge's reasons. The adequacy of the reasons must be tested in the context of the knowledge and understanding of those who are present at the trial. And this is in the present case. Once one reads the pleadings, the relevant extracts of the transcript, and the submissions of counsel, the judge's reasons can be understood. I do not commend them. It should not be necessary to look so closely into the pleadings and evidence, as this court has had to do in order to see what the judge decided. But I do think once that is done, it's reasonably clear why the judge has decided as he did. So you can go into the record and that...
I'm not quite following this. Are you doing this for purposes of JR, or are you doing it for purposes of appeal?
I'm doing it for the purposes of the common law duty to state reasons for a judgment.
Really? Yeah. It's both, isn't it?
Yes.
Because the decision maker has to, part of the issue of rationality is that the proper reasons are given.
Yes. So that's where it's common law duty relevant to both. And I just point out that Lord Justice Morris Kay and Lord Justice Ricks both concurred, paragraph 30 to 31 of the judgment. So that's why it's permissible to go into the record.
Yeah, it's really the educated audience point.
Yes. Mr. Joel made the forensic point yesterday that he couldn't explain to his client why the tribunal decided carriage as it did, to which my submission is, if you sat through the hearing, it's an online hearing, it would have been clear what the focus of debate was about. And those focuses of debate included in particular classes A and B, theories of harm, the role played in theories of harm, tacit collusion, and those are the points of distinction that in the end tell in Mr. Evans's favour. Again, paragraph 389, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, 9, better thought through. So that's common law reasons. I turn now to the judgment. Mr. Joel's taken you through that pretty extensively this morning. He advanced submissions on a number of topics, one of which, and he sees this as being a particularly important one for his client, funding and MTE. And at this point that I propose to hand over to my learned friend Mr. Williams, who dealt with funding issues in the tribunal below and is here today to deal with them in front of your lordships.
My lords, I'll obviously try to deal with this as briskly as possible. My learned friend essentially tries to allocate a point or a point and a half to him based on funding. My learned friend, Mr. Jal, I should say, based on funding considerations. In respect of the actual amount that Mr. Evans has to fund his own case, Mr. Jal attributes, I think he says perhaps half a point, perhaps not. On that criterion, we say definitely not. The CAT rejects this as a factor, because they recognise that the funding position at the point they're determining the question of carriage is just a snapshot of how things stood at that time, when the future shape of the litigation is unknown, when the funding packages and the budgets which they underwrite are therefore speculative, and where this just doesn't matter, because as they find, and it is a finding that was rested on evidence about funding which both candidates for certification put in, if there were to be a certification, more funding would always be available so long as the case remained meritorious. And those are passages which my learned friend Mr. Jal just jumped over, so I do need to show them to you briefly. The first is paragraph 304 of the judgment, which is page 397. Yes, page 397, paragraph 304. So at 304 they say, the Evans PCR drew our attention to the possibility of further funding being obtained, and Donnybrook, that's the funder's willingness to provide such funding, has already been evidenced by two increases we referred to, and that's a reference to Mr. Evans twice having, for example, when the CAT didn't deal with carriage in the way that had been expected as a relatively inexpensive preliminary issue, but rolled it into the sort of state trial of certification. And Mr. Evans went off, he had no trouble increasing his funding in the past, that's what the evidence showed. Although not specifically mentioned to us, we're in no doubt that in an appropriate case, Therium, that's O'Higgins' funder, will also augment its funding. And we do not consider this to be a point of distinction between the PCRs. And my lords, they return to this question at paragraph 324, which is at page 405. They begin, and these are the passages I will on to make good my point that this is just a snapshot at an uncertain point in the litigation. 3241, they note that however much thought has gone into it, it's an exercise in speculation and we should proceed with extreme caution in attaching too much weight to it. And two, they develop that by saying it's very possible in the light of unknown or unanticipated future developments, plans will change. The respondents have yet to articulate a positive defence, though they think it's clear that there will be a vigorous resistance, but the nature of the defence may inform how the collective proceedings are run. And then they say, moreover, as we have indicated, if the collective action is proceeding satisfactorily but costing more than anticipated, we assume that it will be funded further. And they reinforce that in the next sub-paragraph, if I could just take up the last sentence of it. We have no doubt that if and to the extent there is a shortfall, I repeat, a good deal of this is an exercise in speculation, it will be made good. And they preface that with another point which my learned friend, Mr. Jal, just jumped over, which is that on the current state of affairs, the O'Higgins PCR, as they note in the first sentence, has a proposed expenditure of 19.8 million and a budget of 16.6 million. So they've got a £3.2 million hole in their budget. So O'Higgins itself is necessarily relying upon a future facility to go out into the market and augment its instant funds. And it's developing that they then say at subparagraph 4, there is a risk of shortfall on both sides because, and they essentially say that they think both sides haven't budgeted enough, albeit Mr. Evans is somewhat behind. But the actual finding of the tribunal is that it just doesn't matter because there will always be more funding if the case remains meritorious. And if I can invoke the famous epitaph to Sir Christopher Wren at St. Paul's, so if you have any doubt about that, look around you. There is a complete, this extremely expensive appeal for which there was no provision in either the Evans or the O'Higgins' budget, is here being funded by both funders because it's a commercial necessity for each of them to try to protect their investment. And in my respectful submission, that shows as vividly as anything possibly can that what the tribunal says about more funding always being available is absolutely correct. And in any event, that is its finding. And if my learned friends want to disturb a finding by an expert tribunal of that sort, you might have thought it was an issue they would have troubled to mention in their skeleton. But this point doesn't find any mention in their skeleton whatsoever. My lords, I can certainly go further on this, but I obviously need to give some attention to ATE because that's the issue to which my learned friend Mr. Jowl attributed a full point. But it is also important to note, and again, we don't deal with this in any detail in our skeleton because it's not mentioned in theirs, but if it had been necessary to do so, for example, the figure that the CAT gives about the gap between the parties of £2.5 million before you come to the adjustment, because our counsel are on CFAs and theirs aren't. With respect to the tribunal, that figure is wrong. And they note, there's a footnote in their judgment where they say that after the judgment, we wrote to them to say the figure was wrong, but they don't adjust their judgment because it's ultimately a broad brush exercise. But the tribunal, it's a paragraph 314 of their judgment. They say that O'Higgins has spent £5 million odd on ATE premia, that's the down payments, the non-contingent part, 5,087,500. But the correct figure is in fact 6,387,500. So the tribunal misses £1.3 million of ATE premium at that point. And can I say immediately that that figure is O'Higgins' own figure. I understand that there's difficulty with your lordships assessing the electronic bundles, but this shouldn't really be a matter that's in dispute. And so for your notes, if the point were to be controversial, if you go to S3543, page 3543, you will see that O'Higgins' own statement is that its ATE premium down payment has in fact 6,387,000. So there's a £1.3 million understatement. But then there's another understatement in the judgment because they specifically say we're disregarding insurance premium tax. But you can't disregard insurance premium tax because insurance premium tax is payable. And because O'Higgins has spent much more on ATE than we have to date, the impact of insurance premium tax on it is obviously correspondingly higher. And so by the time you take that into account, and the difference between the parties is in fact just £800,000. And then that's further eroded because the fact our counsel are on CFAs, and that saves us another £500,000. And at that point, you're down to a difference in the figures between the two camps, which really is completely marginal. But as I say, one really doesn't need to get into that sort of rather wonkish detail in circumstances where we say the unimpeached finding of the CAT is it simply doesn't matter because more funding is there. And of course, that is vividly demonstrated, as I've said, by us being here today. It's vividly demonstrated by the tribunal recording that before the hearing, Mr. Evans had needed to up his calculations because of the unexpected shape the case took. And there's a final vindication when we see in the figures that the tribunal, through gritted teeth perhaps, but they did admit them, it was seen that post-hearing, Mr. Evans went out into the market and he upped his funding again. So in my respectful submission, once one apprehends all of this, Mr. Jowl doesn't get his half point. And then when I come on to ATE, the key passage here is the paragraph my learned friend showed you, which is at page 411, paragraph 340. And he says there are 2 points of difference. Only one of them did he really develop. The point he developed was the sheer quantum of the O'Higgins ATE. But he also invites attention to the tribunal having prefaced that by referring to a marginal greater robustness in one side's ATE. But it is important to see that the tribunal said that but discounted it. But what they actually say at 341 is both ATE insurances seem to us to be robust. To the extent the degree of robustness matters, it is not a material factor for us. So they take it as so marginal that they find it's not material. We consider the O'Higgins PCR's ATE is marginally more robust. And can I also here emphasise the tribunal rightly saying that they're analysing this from the point of view of the respondents, the banks. And that, in my respectful submission, is another telling indication that there is no ammunition for my learned friend, Mr. Jowl, in this part of the case. Because if there was any serious lacuna in Mr. Evans's ATE insurance, the people who would be hollering all the way from here to Kandahar are the banks. And the banks have taken no point whatsoever on either the amount or the quality of Mr. Evans's ATE insurance. What in fact happens is Mr. Evans, he goes into the market and he negotiates a bespoke ATE policy which already contains clauses preventing the insurers from rescinding or avoiding in all save the most improbable circumstances. The O'Higgins PCR doesn't do that, it just goes and buys some off-the-shelf policies. The banks do object to those and say they're not robust enough. And as a result of that, Mr. O'Higgins has to go, or his company have to go back into the market and buy anti-avoidance endorsements, at which point the banks accept of them as they accept of us that our policies are sufficiently robust. Insofar, again, this isn't a point that finds any mention in my learned friend's skeleton argument, so if they wanted, particularly, if I may respectfully say so before my Lord the Chancellor, to develop an argument that our ATE is insufficient, you might have expected them to mention it in their skeleton, or even to put their own insurance documents in the bundle, which as far as we can see, they haven't. But it perhaps suffices to say that in the court below, my learned friend Mr. Patel was the advocate in this part of the case. Even Mr. Patel characterised the criticisms that were being made of Mr. Evans's policy as theoretical, such as, for example, Mr. Evans being ordered to pay costs, but for some perverse reason deciding not to make a claim on the policy.
So the bottom line is that transient funding differences are irrelevant, provided the CAT is satisfied that over time, both in relation to financing and insurance, the class representative will obtain sufficient protection, both to ensure that the proceedings can run smoothly, but that the defendant is protected in the event that they win.
My Lord, precisely, and indeed we would say, and obviously there's been a debate about sort of last and final offers and such like, we would say that it would be positively detrimental for there to be anything which encouraged candidates for class representative at the outset, as it were, essentially to try to buy to buy their appointment by procuring a superabundant funding package when sufficiency is necessary. Because as you can see from the judgment, AT insurance, for example, is extremely expensive.
But if you therefore ask if the CAT then said we want best offers in by such and such a date, we're going to have a preliminary hearing on the choice of carrier, then it would be sufficient not to actually have the insurance or the funding in place, but to be able to persuade the CAT that you could make provision for it.
That would certainly be our proposition, because anything else is very wasteful. Just to give an example, buying insurance before you get certification
is not efficient financially.
No, and buying insurance before certification, of course, there's a double risk. The insurer is facing two risks, not one. So just common sense, there's actually evidence, but common sense says it's going to be more expensive. And insuring from the very beginning all the way through to an end of a trial, which might not happen. So in our respectful submission, in economic terms, what is being contended for really is extremely unattractive, and that might be why ultimately the tribunal just didn't run with it. It took the view that in qualitative terms, both parties crossed a sufficiency threshold, and that both parties had more work to do in the future. You've seen what I've shown you about funding. I think in a passage Mr. Jowl already said to you, they said the same about ATE. They didn't think that even O'Higgins had enough ETA, but ATE, but they thought it didn't matter. And in respect of ATE, just with funding, my respectful submission, Not only is it obvious that if you need more ATE and the case remains meritorious, you can go off and purchase it. And what the evidence, in fact, should, and it's the one thing I'll take you to before I give way to my learned friend again, what the evidence in fact did show, and no one impeached it, was there was every reason to suppose there would be plenty more ATE to come. And part of the reason for that is this certification dispute, because someone's going to lose it. And when somebody loses it, if it's my client, as the figures stood originally, there's £23.5 million worth of AT insurance, or on their figures there's £10 million more than that. Those insurers have already shown an appetite for the risk. They've pocketed deposit premiums and they can keep them, and suddenly their underwriting capacity is refreed and it's there for purchase by the successful applicant for certification if they want it. So in our respectful submission here again, you can really see that this is a chimera. Just because at the punctum temporis that the decision is actually made, and whether that's made with reference to the evidence at the beginning of the hearing or the material at the end of it, it just doesn't matter unless you think there is a sort of ossified funding environment in which only the ATE, which is extant, and only the funds which are extant, at that point, they are the only funds which can ever be brought into consideration. And when you realise that that's not the case, then in our respectful submission, the CAT was right to treat it as a neutral factor. Before I give away, I have referred once or twice to some evidence about insurance. Because this is a point on which my learned friend Mr. Giles did put really quite a lot of emphasis, it's the one passage I will show you if I may. It's in the key documents, page 698.
So it's volume 1 of the key document.
Yes, sorry, I've only got it electronically, so if someone wants to give me the physical tab.
698.
Yes, it's page 698, which is the third one. In hard copy, yes. In hard copy, the pagination would be 2277, I'm told. Forgive me, I'm using the PDFs.
2277.
It's tab 30, I'm told. Thank you. I'm so sorry for being disorganised on this. Volume 2, tab 30.
Yeah.
Page 2277.
Yeah.
This is the statement of Mr. Chopin, who is essentially our funder, or an emanation of our funder. He says, I've worked closely with the AT insurance market throughout my time working in litigation funding. I know the market and many of its main players very well. Based on this experience, I am confident there will be no difficulties for Mr. Evans to obtain additional ATE following certification should this be necessary. There are two main reasons for this. First, I expect that insurers will review the case as having a lower risk profile once it's crossed the certification hurdle. Secondly, if the O'Higgins PCR CPO is not certified, then I would expect additional AT insurance capacity currently bound to O'Higgins to be released back into the market. In the cutthroat world of insurance, I've already had informal conversations with certain insurers and brokers to this effect. So the vultures are circling around someone, but we just don't know who it is as yet. But my lord, unless I can assist you further, those are the points that I was making on those aspects of the case.
Thank you very much, Mr. Williams. Yes, Mr. Williams.
I just, before I go into the judgment, I just would like to emphasise the obvious point that the CAT's an expert tribunal. I don't need to say anything more about its composition other than to make clear that Professor Neuberger, who's currently Professor of Finance at Cass Business School at the City University of London, does have expertise in market microstructure. He said when he was posing a question to Professor Rhyme, when Professor Rhyme was giving evidence on day 2 of the hearing before the CAT, I would like to move on to the question of size of transaction. I mean, I used to do this in microstructure myself a long time ago, and I'm out of date, but could you just explain the impact of information asymmetry on trade size? So that was on the day 2 transcript, page 4175.
Talking about his skills by the charming Mr. Kennelly yesterday.
Yes. I don't think he actually specifically referred to as market microstructure expertise.
No, I don't think
I'll just interpose this point now. about my learned friend's suggestion that if there's remission, it should be to a differently constituted tribunal.
Yes.
We would strongly resist that. There's no grounds for doing so. The idea that certain points have been decided on his case at this stage against him doesn't mean that they're biased. It just means they've weighed it up and taken a decision, as they're required to do, to prefer one applicant over the other. That's not bias, that's just an exercise of judgment. And in particular, depriving the CAT of the ability to have the expertise. Well, I mean, there may be other members of the tribunal who also have microstructure experience, but to have someone who is read in, as Professor Neuberger plainly is, along with the other two members of the tribunal, so there's absolutely no call for that.
No.
That's all I'm going to say on that topic. The other one, my learned friend couldn't resist slipping in this morning, was the first to file point. I thought we'd driven a stake through the heart of this.
Sorry, what point?
The first to file point.
Oh, the first to file
that
point.
O'Higgins went in on the basis of the Commission's press release. We waited, obtained the Commission decisions through a request to the Commission under the Access to Documents regime, and got the non-confidential decisions from the Commission and used those as the basis for structuring our CPO application.
Well, speaking for myself, you don't need to address that point further. I don't know whether I mean, it doesn't seem to.
My learned friend said we were free riding. Below he said we're copycats. We weren't. This is all our own work. We weren't looking over anybody's shoulder.
The real difficulty with the argument is if you created a first to file, you would create an incentive for people to jump in before they were properly prepared.
It's been looked at in depth in Canada. Quebec has had a first to file regime. It's now modified, but it's that issue. The CAT had evidence on that in the carriage dispute below. I in fact attached a report from the Ontario equivalent of the Law Commission to its judgment on the carriage dispute issue, summarising the various arguments that have been considered in Ontario. And Ontario indeed then proceeded to change their class action proceedings regime. And just a footnote point, just remember in Canada, of course, class actions are across the board. They're not restricted to competition cases as they are here.
If you're right that what should happen is that the CAT determines carriage disputes right at the outset before certification, then you're in fact going to create a narrow window anyway, aren't you, effectively, for people to come out of the woodwork.
Yes.
Because people will have to get their skates on if they're going to participate in a carriage dispute, because it's going to be the first thing to be decided, and you would have thought relatively quick.
Yes. And if we'd had our time over again, we would have informed the CAT a bit earlier than we did that we were waiting for the Commission decisions, because that would have been relevant to the timing of the first case management conference.
So, good to encourage people to get carriage disputes over and done with.
Yes.
But not by imposing a sort of first past the post type rule.
Yeah. The race to the courthouse. Again, there's quite a bit of Canadian jurisprudence on this from various of the provinces.
I can't offhand think of many areas of jurisprudence where the first past the post race to present your proceedings actually has any great merit.
None occur to us.
No.
But that's really Mr. Joel's point, not mine. So we're not a copyright, we're not free copycat, we're not free riding. Turning to the judgment itself, as you've seen, both the majority and Mr. Lermas, who dissented, showed marginal but clearly expressed preference for Mr. Evans's case. Carriage, it's a separate decision, but the consideration of the issues were not hermetically sealed.
Did Mr. Lermas say separately why? That's one point I don't think I picked up.
No, what he says is at paragraph 463 on page 459.
Yeah.
And you'll see there that
He says all that's finely balanced, I agree with the view of the majority.
So he'd obviously, it's a lengthy dissent, it's the lengthiest dissent encountered in the CAT in its 20 years or so of operation.
There's only been one other.
Mr. Ridyard has recently dissented on economic analysis of Passon. I think that's in Royal Mail. Dermot Glynn, an economist, dissented in the Federation of Independent Practitioner Organisation cases, which was Mr. Kennelly's case, which went to the Court of Appeal on the basis of that dissent, but wasn't any more successful. So it's certainly the first really substantive legal dissent in the CAT. We've got economists, Mr. Ridyard and Mr. Glynn, dissenting previously. I've got at the back of my mind there's one other one. But
I mean, the paragraph 463, the last sentence is quite striking, isn't it? Because that ties in really with what the majority say, because he refers to the 3895 about better serving the interests of the victim, and also the previous paragraph about better thought through, represent to our mind a marginally better attempt at capturing an elusive loss. All of which suggests that this is nothing to do with assessing the merits of the claims or anything of that kind.
Yes, in the hearing below, the perspective it was about serving the best interests of the class of victims of this anti-competitive conduct. That's perspective. That's why Mr. Evans is here as a PCR seeking to represent that class. It's vindicating the rights of victims. When one looks at the analysis in the judgment, and I'm going to come to a couple of points of difference. They are the two key differences between Mr. Evans and the O'Higgins PCR identified in paragraph 196 on page 332. And you'll see there at 196, paragraph 3, while both applications contend that the infringements found in decisions would have enabled the respondents to make trades in the inter-dealer market at the expense of non-respondent dealers, and this would lead to wider spreads on the customer market, only the Evans PCR contends that the infringements would have allowed the respondents to widen their spreads to customers through a process of tacit collusion. And then the second point of difference, the O'Higgins claim identifies a single class of claimant, implies in customers of both the respondent banks and the non-respondent banks. The Evans claim distinguishes two classes. We just disclose that further. So these are the two key points of difference. I'll deal with the two.
I'm not sure that's right. 196.2 says that there are many differences. Some of them, detailed definition of classes and the trades that are covered by the claims, will be discussed further below. Other differences in the details of the economic reasoning are of not great significance, but two differences are worth mentioning, so that the two differences worth mentioning that you go on to deal with are a subset,
yes,
are two of a subset, but the first sentence of subparagraph 2 identifies other differences which the CAT also takes into account.
Yeah. So I'd refer to them as key differences, as was the two they specifically.
The trade's covered by the claims point.
Sorry?
They say in 1962 the trade's covered by the claims.
Yes.
Which they discuss further below. And is that picking up the point that Mr. Jarl made, that the two categories of trade of the three identified by the Commission, which he says, well, your theory of harm, and your class definition doesn't include those two categories, therefore
Yes.
he's better putting it colloquially.
Yes, we defined the classes to exclude trades that the O'Higgins PCR does include within their class.
Mhm.
Yeah, that's a difference. But if I could just focus on the Class A and Class B distinction. I've just got one eye on the clock here, because we spent a lot of time on this. As we've identified during the course of the last 3 and nearly a half days, when it comes to Class A and Class B, those are distinguished. The classes come from Professor Rhime's report. So it's Professor Rhime saying that in his expert opinion, the harm vis-a-vis respondent banks would eventuate differently to the harm vis-a-vis respondent banks when they're not participating in the cartel and non-respondent banks. And that then poses an issue as to how you measure that harm. Now, obviously, it's going to involve analysing data. Class A depends on disclosure from the defendants. That's obviously what Mr. O'Higgins proposes to do, it's what we propose to do. But when you come to the Class B claims, you can't rely on disclosure other than from the respondent banks during their Class B periods, their non-infringing periods, because cartel non-participants are self-evidently not parties. This was something that was explored by my Lord Justice Snowden on day 1 with Mr. Joel in relation to Professor Breeden saying, well, I would extrapolate from the data that we get from the defendant banks. And Mr. Joel further explained that process of extrapolation for that would involve getting data from the defendants for their, what we call their Class B periods. And so you would have data in the form of disclosure from the defendants for periods in which they didn't participate in the cartels. And he did that by reference to a chart. You remember the coloured chart with the different bands, the two different decisions. Yeah. Now, that chart of infringement periods was exhibited by Professor Breeden to his first report. In other words, that's the report that went in with the CPO application. But he didn't exhibit it for that purpose. He exhibited it to show the duration of the infringements. He didn't, in his first report, say, by the way, this shows that I can get disclosure from defendants for periods in which they weren't involved in the cartel, and that would enable me to have some data from which I can extrapolate for claims for non-infringing claims against non-infringing parties. That explanation only emerged in his third report, which was served in June 2021, shortly before the CPO hearing. The reference for that...
Is it any the worse for that? I mean, is it
it goes to this one, Lord. It goes to which party was better prepared to pursue these claims on behalf of the victims. This point about access to data was spotted right at the outset by Mr. Ramirez. And it's there in his first report served with our application, where Mr. Ramirez says there's a problem with Class B because they're not defendants insofar as they are or getting data from non-defendants.
We read this subparagraph 4 of 389 as effectively saying, when they talk about the claims articulated, it is the fact that you're running A and B and Mr. Higgins is not. And since that's obviously going to be quite an issue in the case, I think they're saying this may be a marginal difference. That's their evaluative judgment of the two cases side by side as of the date they took their decision. You pleaded it, they have a different approach. And I understand it to be, well, that's going to put you in a marginally better position moving forward through case management, preparation of evidence, preparation of exports reports, how you present the trial. It may fail at the end of the day, and Mr. Jal might be absolutely right, but from their perspective at case management stage, that looks to be marginally better articulated. Is it any more than that?
It's this bit more. It is Mr. Joel's submitting that Professor Breeden is a leading expert in this field, and that this is how they get access to data.
They've all got marvellous experts, so they don't distinguish between them.
But the point is that they only spot the point about data when prompted by Mr. Ramirez. And we see this, I mean, throughout the judgment, indeed throughout the discussion of the last 3 days, whenever you've wanted to have a look at a data point or a statistic or some sort of delving into what's going on, that's all information provided by Mr. Ramirez. For example, the 42,015 estimated class members. All of that's from Mr. Ramirez. Professor Breeden and Professor Bernheim don't do anything like that. All they do is stand, not quite on the sidelines, but they then criticise various aspects of how Mr. Ramirez has gone about it. But the point is, we went about this from the very start. And so when the tribunal is going through all of the evidence, the starting point is Mr. Ramirez. Working on the basis.
It isn't what they say. I mean, we're just relying on, you're reading into a lot between the lines. I mean, we have to be persuaded that that wasn't a valid exercise of judgment, a marginal, better articulation of a claim to capture an elusive loss.
I'm responding to a point made by Mr. Joel, and just to say there isn't really anything in it. What he's relying upon is what Professor Breeden did once he'd spotted.
Well, it goes back to your point
And
it
so
may be that 389, 4 and 5 are exiguous, but you're entitled to look at the totality of the position with an expert tribunal which had heard the matter over how many days it was with an absolute welter of evidence, expert and otherwise.
It was 5 very long.
It's not just sort of doing that, is it?
It's not. It was 5 very long days. The tribunal sat early and sat late. It was all online. Professor Bernheim joined online from Stanford. Mr. Ramirez joined online from New Delhi. So it really was a very modern online hearing. Well, I've made my point there about source of data and how that has been thought through from the very outset by Professor Rhyme and implemented by Mr. Ramirez. It also, the point that your lordships have made is that the CAT was looking at matters as they had finally arrived at the time of the hearing, is also that they were, to some extent, looking at the process by which the parties had arrived at the position before them. And we can see that in relation to the second point of what I refer to as the key points of distinction, tacit collusion. And that is the reference in the tribunal judgment at page 367. And that is paragraph, if you could encourage the tribunal to reduce the number of subparagraph numbers as well.
238.
So it's 238, subparagraph 3, little Roman numerals 2, where the dealing with the averment of collusion in the setting of spreads contained in the O'Higgins theory of harm submissions is, in our judgment, new to the O'Higgins application and reflects a point pleaded in the Evans application. And they say, and this is criticising the O'Higgins pleading, and they make the point that you've just made. We take no issue with the assertion of an apparently new point by the O'Higgins PCR, but would only observe that this is a form of direct loss that will have been sustained by those counterparties to the respondents who dealt with the respondents in circumstances where the rate was not the market rate. In short, this is not a consequence of an unlawful information asymmetry case. It's not caused by ASI, but is a different loss caused to participants in the market who dealt on the basis of non-market rate spreads. And that's a point, as the Tribunal points out, was made from the outset by Mr. Evans. It seems to us that this type of loss needs to be distinctly articulated, and we consider it further in relation to the Evans application, where it has always been pleaded. So, if you're putting yourself in the position of the tribunal as to why they have come to the conclusion that we're better placed, that's something they identify, that we are better at spotting a point, often a key point, when it comes to capturing elusive loss. I've come under time. Unless I can assist you further, those are just other submissions.
Can you tell us about the point about the two additional classes that weren't included from the commission decision?
Yes, these are the benchmark trades.
And the tribunal don't seem to deal with it, so far as we can tell. It's obviously something that was debated before them, although certainly in the documents for the appeal, let's say grounds of appeal and skeletons, wasn't a point that was made particularly strongly, if at all. But Mr. Jarrell did rely upon it. So what's your answer to it?
Just simply that Professor Rhyme explains in his first report filed with the application why he doesn't think that benchmark trades and resting stop loss orders cause harm on an aggregate class-wide basis. That's because
market-wide harm.
They're not market-wide.
They're limited to the particular trades.
To the particular trades, and more, as importantly, someone trading FX, say a benchmark is manipulated down so that people end up selling at a lower price than they would otherwise do. Well, that's bad news if you're seeking to sell, but if you're seeking to buy, it's good news. And those people are both trading FX.
Yeah.
And so his view was, well,
You can't establish commonality.
exactly.
Is it summarised at paragraph 43 at page 2035? 2035.
Of
I think it must be the supplemental.
The key documents. Yeah, paragraph 43.
yes. And then in particular paragraph 43.
Yeah.
Okay, well,
So it was hotly debated.
We had, Mr. Joel gave us some references where the thing was hotly contested. So where did the tribunal, if at all, come down on this, or not at all?
They don't seem to have come to the view that they need to decide the point.
I mean, Mr. Jowl trailed with us the idea that it would be wrong as a matter of principle in formulating your class on a collective action follow-on claim to leave out of the class somebody who has suffered loss as a result of conduct found to have been anti-competitive by the Commission. Your answer to that is only if they can be fitted into collective proceedings, and if their particular loss, which may have been suffered, can't be fitted within the commonality of interest issues collective proceedings, then actually they shouldn't be there, even though that's a shame.
Yes. Yeah. There was a feature that Mr. Evans, at the beginning of the hearing, both the tribunal invited both Mr. Evans and Mr. Higgins on behalf of the class representative to make a short presentation to the tribunal. They weren't sworn, it's not evidence, but this is one of the topics that Mr. Evans covered and explained why, looking at the advice from Professor Rhyme, he took the view that those trades should be excluded. So it's a clearly taken rational decision right at the outset. If the tribunal thought we got that completely wrong, it would have said so. I can't imagine Professor Newberger standing on the sidelines and saying, you know what, let's just ignore all of that. In fact, it was a point actually raised by Professor, I keep calling him Neuberger. Professor Neuberger did raise it of his own motion during evidence, talking about press reports about these sorts of trades, and then we then went to an explanation as to why they weren't covered.
Yeah. Okay. Thank you. Mr. Kennelly, you don't really have anything to say on any of this, do you?
A very short final word on sending the case back to the same constitution. That's nothing to do with this issue.
Mr. Giles finished.
That's less than a minute. It's literally one short comment on sending it back to a different constitution.
My lords, difficulty that we have here is that we simply don't know what the relevant paragraph of the judgment is referring to. We know that it refers to the strength of the claims, but we are all speculating about which aspects of the claims are in fact supposedly advantageous. Now, one possibility that is proposed by my learned friend is he says, well, look at paragraph 196.3 of the judgment and look at paragraph 283.3.1 of the judgment, where it is asserted that only Mr. Evans contends that that spreads would be widened, and only Mr. Evans puts reliance on it. And that if that had been articulated, then we would have said, as we do say in our main appeal, that that is simply wrong. And I showed you Professor Breeden's first report, paragraph 4.4 and 5.9b, and 6.22 to 6.33, where he refers on all of those occasions to collusion on spreads. And Professor Bernheim also refers to it in paragraphs 39 through to 43. So if that is the reason, if there was a misperception that somehow only Evans was well, there clearly was a misperception that only Evans was relying on collusion on spreads, and if that is the reason, then it is manifestly flawed on the basis of the evidence that's there in black and white for you to see. And that illustrates in our submission how this does interrelate with the main appeal. One can't say that that is an incorrect criticism of our pleading, which it manifestly is, and then say, oh, but nevertheless it's safe to say that one prefers Evans on that basis. And I think that just simply illustrates the point. Now, the other possibility that's canvassed is the possibility that they didn't like the three trades, and the third possibility is that they did like Class A and B. And the difficulty with both of those is that they are referred to in paragraph 299, 291 to 292 of the judgment. And if I could invite you to have a look at those, go back to those. And you see they refer to the point that we make about the width of the classes. And then they refer to the point about the distinction between direct and indirect harm in Class A and Class B. And then we see in paragraph 293, they say, in conclusion, we consider that, at least given the points articulated by the applicants in this case, a relative evaluation of each approach will involve a consideration of the merits into which we cannot and should not be drawn. So at this point in the judgment, they are saying very clearly that these are not points that go to relative suitability. What we do have in the relevant
I suppose you would say as well that
yes.
their quote, they end their quote of the
Yes.
Evans skeleton, I think before at least one of the points which I just ventilated, I think.
Yes, yes. And there are other difficulties with the suggestion that one can interpolate these points into the relevant paragraphs of the judgment. I mean, and it is all. It is wholly unsatisfactory, because there are a number of points that are made that go back and forth. And my learned friend said, well, if you sat through the hearing, it would have been clear. Well, respectfully, that's a sort of, if you were there, you'd have known point. Well, we respectfully say, if you'd sat through the hearing, you most certainly would not have known what points were of interest to the tribunal in this part. And there are such a
depends on all sorts of factors, doesn't it?
Yes.
And, I can't speak for Mr. Justice Marcus Smith or his colleagues, but some judges sit there and say absolutely nothing at all.
No.
Like us. Some judges intervene all the time, which we of course don't
Yes.
do. Some judges intervene all the time, and even when they've made the interventions, you find that actually the result is completely different from what you thought it was going to be.
yes, yes. My lord, that is true. and the one, but to give you an example of the sort of intricacies of these issues and why it is not a good idea to decide them on the hoof, and I just make this point just to give you an illustration. If you take up the second supplemental bundle at paragraph 24, and we go to tab 24. Yes. Now, this is the respondent's joint CPO response. And if you go over to page 1872, you see what they say. They talk about Mr. Evans' proposal to exclude benchmark. Mr. Evans proposes, they say, to exclude benchmark transactions, limit orders, and resting orders from the scope of the proposed action. However, contrary to Mr. Knight's evidence, the respondents do not hold data which enables these transactions to be reliably identified across the claims period, as Judge Schofield held in the US certification rule. And then they quote the judge, and he says in the underlying passage, identifying and excluding benchmark trades and resting orders cannot be accomplished through generalized proof. Rather, a fact-intensive, individualized inquiry would be required. For example, a review of the relevant communications between class members and defendants. That would be an enormous undertaking. So no wonder the respondents wish you to favour Evans, because not only is it a narrower class, but it can't be done on their methodology. Their methodology you can't actually exclude these orders. So I don't make a huge point of that. I just shows you the sort of complexity of these issues, and the fact that it cannot just be supposed that there was some sort of obvious preference.
Hang on.
Yes.
What about in footnote 92?
Forgive me.
Should be excluded from the phrase.
I mean, they're talking about data.
Yes. Yes. So, well, of course, they want them excluded from the class, but they also say one doesn't have the data to do that.
No, it says you can't do it by generalised proof. It says it's an enormous data exercise.
Yes, an enormous data exercise, an enormous undertaking. So they say
that can be done, just going to cost a lot.
Cost a huge amount. Yes, going through every single trade and doing. But I don't.
Right. So
I'm not making.
Your point is that they're not agreeing as a matter of principle. They're agreeing because it just.
It suits them. Yeah, well, so these are the. My point is simply that these.
But Judge Schofield's ruling, as I read that ruling,
yes.
that's exclude. He's giving reasons for excluding these two classes because it would all depend upon the individual circumstances.
He refused to certify it altogether.
Yeah, well, there we are.
Because
he said, I won't certify because this is these are examples of categories of people who have individual positions which may or may not mean they've suffered a loss. And that means there's no commonality of issue.
Well, but that's under the American approach.
Well, that may be right.
And that's not under the UK approach. And this is another, and this is the other point that I would like to just emphasise, which is that the principal debate about the exclusion of these trades was a legal one, not an economic one. The principal debate was between myself and Ms. Wakefield, and I gave you the references, and I don't plan to take you through them. But we had a long debate, which was almost exactly the same, about as the debate in Gutmann, about the extent to which you have to say that everyone in the class has suffered loss. Or can there be some instances of some of these trades where somebody might have benefited? You remember in Gutmann there was a small, and it was almost identical authorities cited, and it was argued that it couldn't be done. And this is why this is just such a treacherous exercise in trying to interpolate, because it could be that they agreed with Miss Wakefield. If they had done so, they would have made an error of law. We would have been able to appeal on that ground. But one simply doesn't know, and it's infected by the erroneous findings on the merits generally, and the unfairness of that procedure, that where only these allegations about our claim were only put in the judgment, clearly, and we didn't have a chance to respond to them. And so if that is an unfair procedure for ascertaining the merits of opt-in, opt-out, it's also unfair when it comes to carriage, because simply had, for example, the point that I mentioned regarding the allegation that only Evans alleged collusion. Well, if they'd said, this is a new point, when we would have gone back to them and said, well, actually, no, with respect, we did allege collusion. Look at all of these paragraphs in Mr. Breeden's first report. You've misunderstood it. It's a contributory factor. This is a point of greater subtlety than you appreciated. So it's wrong in our submission to seek to interpolate, and particularly wrong in circumstances where there has been an unfairness in procedure and wrong evaluations in substance. And I do understand the desire of the court to seek to salvage a decision on carriage and not to prolong matters, but it can go back to the tribunal if necessary, and it can be resolved expeditiously, but it must be resolved, in my respectful submission, fairly. And this is not a fair resolution of the outcome of the carriage dispute. And people are looking to this as one of the first carriage decisions. And it has simply not been resolved in a fair or even comprehensible way. Now, just briefly touch on one other point, which is the point about funding. Now, I'm certainly not going to get into Mr. Williams's various points about the niceties of the funding position or the terms of the ATE. But I do say that it is clear on the face of the judgment that the tribunal considered that a significant point in favour of O'Higgins was the fact that it had £10 million more of ATE, and that it did not find, as Mr. Williams suggested and has been submitted below, that this was trying to buy carriage by effectively buying too much ATE. On the contrary, the tribunal said this is not enough ATE, and it did find it in terms a significant factor in favour of O'Higgins, and it is the only clear objective factor that is found in favour of O'Higgins, and the only factor that is found against it is one that is expressly related to strength of claims. I'm afraid one can't get away from that, which is not a lawful consideration, and is entirely opaque. So, my lords,
I think what's said against you, and it's
yes.
a very quick question, is that whole concept of taking a snapshot of who's got the most ATE at a particular point in time
yes.
is actually not the way to go, because the real question is, given the availability of plentiful funding in the market for this type of claim, the real question is can each of the claimants get ATE insurance at ever increasing amounts as and when required?
Well,
and given that I think is that the tribunal reached a finding that as and when more ATE funding was required, the market would provide it.
my lord,
it's a neutral point.
No, well, my lord, first of all, the tribunal did not make a finding that they would obtain any ATE as and when. They said they would find funding, that funding would likely eventuate. They did not talk specifically about ATE, and the tribunal clearly finds the ATE factor in terms is a point in favour of Higgins, and you see that we talk about it being a significant and a material factor in favour of Higgins, and it was, because one can't, if one's going to say, oh well, you'll always get funding, then one might as well say, well, funding is just not a point, and you have to say, one has to. There is a difference between somebody who has actually got ATE, and the ATE market is not bottomless, and somebody who's not got it. So we say I simply rely on the tribunal's own finding that this is a significant factor in favour of it. And
they said
and
that
I
it
say
was a material point but of limited weight.
yes,
And the reason why it was limited weight is because neither of you got enough to cover the respondents' costs.
that's right. Which
So
is yes,
to say it was a significant factor,
yes.
I think is overstating the point.
A material. They do say it's a material factor. They say it's a it is, and it is clearly a factor. So if my learned friend is saying that finding should be overturned by way of respondent's notice, then we respectfully say that's wrong. That is a £10 million of ATE is substantial, and it corresponds, as I said, to a factor that the tribunal was obliged to take into account, which is the ability to pay the defendant's costs. And if you actually have ATE, that is one thing. If you just say, oh, don't worry, I'm going to find it, that is another. And that is entirely, and well, can't have it both ways. I mean, if there's an ambit of discretion here, then they're entitled to exercise it plainly in favour of regarding £10 million additional ATE as a material factor. So those are my submissions. In relation to jurisdiction, I should just mention that I do rest my case on the fact that we have a wider claim for damages. And it's important to appreciate that dividing the class between A and B does not make the class any wider, but excluding benchmark trades and resting orders makes it very substantially smaller, and that excludes certain class members from ever getting recovery for those trades. And we do say that that's simply a point that plainly ought to have been addressed in the judgment. And therefore, we respectfully say that this part of the judgment also cannot stand.
Yes, my lords, if in the unlikely event that you are against me and the matter is to be remitted to the tribunal, it would be completely disproportionate to send it back to a differently constituted tribunal. These three members, including Mr. Lomas, are fully read in, and it would be wasteful to require a different constitution to read in. Secondly, if you remit, it'll be because of an error of principle or approach. The President is an experienced High Court judge and will faithfully follow the guidance that you give him. And finally, it's well established, Lochabail in the Court of Appeal and other cases, that even adverse comments about evidence earlier in the same case or in a previous case, adverse comments about witnesses, does not amount to an appearance of bias without more. There's no question of appearance of bias.
But it's not suggested it does. It's not a case of bias.
That's all from me, Marlon. Thank you.
Right, thank you. Right, well,
Judgment of two.
slightly Are you ready? Thank you all very much indeed for, and we are conscious that it's not just the leading counsel who have addressed us, but it's all the solicitors and juniors behind you. And it's obviously a huge piece of teamwork all round in what is a very interesting and difficult case, which has been extremely well presented. Whoever wins, you will not get judgment at 2 o'clock. We will reserve our judgment, and we will obviously let you have it in draft in due course. I'm always enjoined by the Master of the Rules to remind you of the terms of the embargo that are on the top of the judgment, and making sure that there's no question of anybody leaking the judgment to anybody else, which will be contempt of court. If you could please provide us with any typographical or similar errors, not an excuse for inviting the court to reconsider its decision. And if possible, you can agree a term of a form of order before hand down. If you can't, we'll deal with any outstanding interlocutory matters or procedural matters in writing. The costs issue, I think we'll have to leave it slightly fluid depending upon how long the appeal that we're hearing in the week after next lasts. It's down for 2 days, on a Tuesday and Wednesday, but we have ominously got Thursday as a reserve day. I would have thought that if you could be ready for Thursday morning, that would help. Sorry? I think it does. Sorry? Well, I know. Maybe it's affected by our judgment on what we've heard so far.
Well, then, there are clearly many circumstances in which the JR would be academic, because obviously the tribunal essentially said no orders to cost because you both lost, and if as a result of your lordship's judgment.
One possibility, have a think about this. Perhaps you could write to us. One possibility is that we defer the issue until after we've handed down judgment on what we've heard so far.
Yeah,
and we would obviously afford an opportunity for a short hearing at that stage.
Yes. Well, can we we'll discuss that internally? But I can certainly.
Yeah, if you would, rather than trying to deal with it on the move at 1:10. If we have to hear it, or if you decide that we should hear it, before we hand down judgment, then we will make time available on the 11th if we can.
We're much obliged.
Right. Thank you.
All rise.